Hi, good afternoon, everyone, and welcome to today's second Wednesday coffee break session, where we are going to be talking about some of the new laws and practical effects surrounding some of the surrogacy laws and issues that just went into effect in Michigan. So today I have two attorneys here at Foster Swift who know way more about this topic than I do. Gabrielle and Jennifer, thank you both for taking time out to speak with us today on the new surrogacy laws and some of the estate planning implications of them. So I'd like to start right off and hop right in. Jennifer, can you tell us a little bit about this new law? It's my understanding that this kind of completely flipped, the process, complete 180 here as to what we are allowed to do and what we aren't allowed to do. So love to hear about the new law. We can talk about the practical effects afterwards, and then we'll hop into estate planning after that.
Sure. Well, the biggest thing I think everybody is paying attention to with the new law is that surrogacy can now be a compensated arrangement in the state of Michigan. Prior to this new law going into effect, it was a criminal act to pay somebody to carry a baby. And the other, I guess, related thing to that was that surrogacy agreements were considered void. So really, all you had was the party's intent written in a document, and it may or may not be held up in court. Um, I think the other big difference is now we have a roadmap that we now know the qualifications for the surrogate. Those have now been codified in a law. We have the requirements in a surrogacy agreement. And now what makes it really easy is so long as you have followed and met those requirements, the intended parents pretty much are going to be guaranteed legal rights of the child. Now, of course, I'm glossing over that. There's a lot more to it. But before we had to submit a memorandum, and I think there was a lot of, fingers being crossed that the surrogate wasn't going to change her mind because that would obviously override a lot of things given Michigan's law. But I think this will take care of that for us right now. And in terms of other changes, I think this will become much more common in Michigan. And so, things like health insurance and life insurance and short-term disability, all those things that intended parents have to supply to the surrogate as part of their agreement, I think those areas are going to grow too. And I think the law will then catch up to make some of those things more straightforward.
Yeah.
The new law right now is lacking in, I think, providing some of those things. And in my practice so far, I don't see how you don't. So we will probably see changes in all of the above.
Sure. Well, and any new law that inserts these brand new concepts, right? There's always that catch up time, right? No one, strikes a perfect law the first time, and as the process plays out, we'll continue to find new areas that we may want to improve on in this law.
Mhm.
And it's funny to me because I have a sister who lives in Oklahoma, and while it's not on a 100% equal comparison, she adopted some kids, and that process, even though it was codified in Oklahoma, was really an extended, very frustrating process with a lot of crossed fingers and hopes, as to whether or not they would get the child and things like that. So I know just how devastating that could be. And seeing that there's a little bit more certainty provided, I think is huge, right? It
Absolutely.
really is an area that is difficult to deal with from a practical effect. And I sometimes get the argument from beforehand where we didn't want to pay surrogates for it, and deprive someone of that child that they may have carried, but it's a contractual relationship. I mean, it's one of those that I think as long as everyone goes into it knowing what's going on, those should be enforced. So I'm glad to see that the law is really catching up there. So
Rob, if I could jump in on a
yeah,
couple of things that you mentioned. Um, yeah, being able to pay a surrogate has thus far until this month been illegal in the state of Michigan. So I think a lot of times surrogate gestational carriers were kind of doing it maybe under the table being paid, being compensated in different ways. But as someone who has been pregnant and who has had children, it's not easy. It's not something I I would do it for a very small number of friends and family members of mine. And it should be something that you're compensated for. And if you've got to miss work and you've got to hire somebody to take care of your other kids, or hire somebody to clean your house, or be on bed rest, or there are so many other factors that can come into play here. Being able to compensate that individual is so important. And this new law is also having some effect on other tangentially related areas as well. So I have a couple of different sets of clients right now, who they are both same-sex women, married couples. And in both of these situations, one of the moms gave birth to a baby that is her biological baby and the baby of an anonymous sperm donor. So in both of these situations, the parents reached out to me, and the mom who did not carry the baby and did not give birth to the baby said, "Hey, is there anything I need to do to protect my legal status as a parent of this child?" And I said, "Well, yeah, technically you should adopt this child. We use the exact same process that we use for a step parent adoption, which it's not a step parent. This is this kid's parent. It's been this kid's parent since day one. But our hands are tied as it stands right now. So we've got to use the same process, which means the parents go through a home study. They submit letters of reference. They're hiring me, so they're paying attorney fees. There are several different steps they have to take and different hoops they have to jump through just in order to make sure that non-birthing moms' parental rights are enshrined in the event that there's a divorce, but also in the event that birthing mom, I should say, dies. We
Yeah.
we didn't really know what would happen in that worst case scenario. So this new law is alleviating some of the hoops they have to jump through. Currently, because the new law hasn't taken effect yet, we would have to publish notice to what's called the putative father. So we know there's not somebody who's in that role as father. It was an anonymous sperm donor. There's a signed agreement between the woman and the sperm bank, which says dad is never going to come out of the woodwork and try to be a dad. But the court rules say we have to publish notice if we're going to terminate this individual's parental rights, which is, in my humble opinion, just completely outrageous. And these women have done all the right things to make sure that there is not going to be anybody coming out of the woodwork. So in my scenarios with my clients, they've both said, you know what, we're going to wait until the new law takes effect, and we want to have our final hearing after that date. So we don't have to publish notice, which would be actually publishing notice for 3 consecutive weeks. And then we would have a hearing for birthing mom to offer testimony to say why there's no dad and why we can't locate this dad. Judge would terminate dad's parental rights. And then there's also a 21-day period for a dad to come forward and appeal that decision. Thank God this new law is coming at a great time, and it will alleviate those steps that these clients of mine have to take. So it's having some unintended effect, I think, on other areas that are kind of related, but in my opinion, really great changes to make to benefit people who just want to be parents to their kids.
I want to piggyback off what you just said, Gabe, because coming from just a human standpoint and someone that was an intended parent using a gestational carrier, having infertility, that's a medical diagnosis. So if you have cancer, right, there's chemotherapy, there's radiation, there are things available for your medical diagnosis. And part of the new requirement out of the act is you're infertile. You've been diagnosed with infertility. So the fact that that's not been available to more people as solution for your medical diagnosis is just blowing my mind. And I mean, you said it right. These people want to be parents. I don't care what gender you are. I don't care what your sexual orientation is. You deserve to be a parent. So, I think it's also solving a lot of maybe social problems that we have had. And so I think that's also a relief too.
Good. Well, I think everyone on this call agrees this is definitely a positive step forward. It sounds like it's an overdue, step forward, and a lot of ancillary things that are being impacted. So, can we talk a little bit? Let's get outside the four corners of the law, right? Because the only people that like staring at laws are lawyers, right? What is the practical process here, right? What is kind of changed? What can people look forward to, under these new laws? Where does the rubber meet the road with these new laws and these new rules and regulations?
Sure. So I am finding that really the process is going to be the same that I went through before this new law takes effect, because really there were boxes you should check. I mean, we all know they're to be thorough, right? So everybody up front, surrogate and intended parents, still have to go through a medical evaluation and a mental health consultation, as the new act says. What that really means is the intended parents and then the surrogate and her husband both have to have some form of counseling. And the act specifies what professional is qualified to provide that counseling. And then the gestational carrier or surrogate can go through a psychological evaluation to make sure that she has a healthy mindset in terms of what you are undertaking, the responsibilities, as Gabe said earlier, in terms of the risks that come with a pregnancy and the toll that can take on your life. You're giving up a lot. And I would say this is an emotional challenge like you will never probably see in your life. And so it's a big deal. You have to be prepared for it and know that things may not go as planned. Um, and I think then it's really more about testing and trying to get everyone figured out in terms of the IVF, what kind of drugs are we going to use, what kind of course are we going to be on, how are we going to do the transfer, and of course that's up to the medical team. And then once that happens, really by that point the surrogate and intended parents have had, I think, enough interaction with each other that they have a pretty good idea of how they want their relationship to look. And so then that's where the lawyers are going to get involved, because you need a surrogacy agreement. And again, the act now tells us what we have to have in order for that to be valid, and in order for the intended parents to have that legal right.
From
And
a high
that
level overview, what is, kind of required under the surrogacy agreement?
So right now we have, like I said, the mental health consultation, the psychological testing, got to make sure that's all there. And then it's in terms of, how many embryos are we going to transfer? What happens if there is a defect with the child? Are we going to terminate the pregnancy? Are we going to carry the pregnancy surrogate? Well, guess what? This is a surrogate's body. So your agreement's going to say that the surrogate at the end of the day is going to make decisions about what happens with her body. As an intended parent, that can be kind of difficult because those are your embryos. But again, going back to Gabe's comment, this is a huge sacrifice to carry a child for someone else. So that makes sense. The act also still requires expenses be paid. So even under the law now, intended parents still had to pay related expenses. So if you have co-pays, pregnancy clothes, if you need a babysitter because you're on bed rest, or things of that nature, and now that's mandatory, that has to be part of the agreement. And like I said, you have to have an understanding of those expenses. I'm trying to think. The other thing, as I was saying earlier, that I would like to see become a requirement is the short-term disability and life insurance policy, because of course there is a huge medical risk when you're pregnant and you never know what's going to happen. And it'd be nice for the surrogate to have that coverage and that
Yeah.
plan to fall back on. Right now, with my clients, we're doing up to 8 weeks of the short-term disability, the life insurance policy to cover the surrogate 8 weeks following the delivery. So
So
it's a lot, but
yeah,
it works.
it doesn't sound like this is a minor agreement, right? This
No.
isn't a back of napkin thing. This is something that really needs to be thought out. To me, it sounds like there are a lot of practical issues that need to be dealt with that if you haven't done this before, you may not see coming, right? It doesn't sound like something, again, that's just a very simple, run of the mill. this is one of those things that you probably want to get an expert involved with that's done this, that lived through this, that knows where to push. For example, just you were talking about some of the short-term disability issues. We don't have it as a requirement of law, but it doesn't mean you can't negotiate it into the agreement itself, right?
Right.
So, just following the steps of the law, that sets a floor, right? You can always negotiate, above that floor, depending on which side of the transaction you're on. So, definitely sounds like something that needs to be, taken incredibly seriously.
I
Now,
want to add one more thing
yeah.
as a practitioner I've run into while we're talking about things in the agreement and the law does not require. From the medical standpoint, there should have been FDA testing done on your embryos and on the intended parents. Right now, it is a gray line, and you can sign, I guess that away and say, okay, we know you didn't do it because the law changed at some point in time. So my intended parents right now had embryos that were preserved from 6 years ago.
Mhm.
And they are trying to get these embryos approved to transfer to their surrogate. Well, they had some red tape with the FDA requirements. And luckily, their clinic is going to let everyone sign a waiver and move on with that. But that might be one of those sticky issues in the future. Because if you think about it, you never know what can happen. I
Yeah.
mean, right? You never know what health issues might be passed back and forth. And so if you are dealing in this situation, just highly recommend from the beginning that all that FDA testing and, like I said, be as thorough as possible because it's a lot is at stake. You don't want to find out, oops, I didn't do it.
Yeah.
um, because that won't go over so well.
Yeah. Well, and again, it gets back to our comment of, the law sets the floor, right?
Hmm.
There's what you have to do and what you should do, right? And those are sometimes very divergent, right?
Hmm.
So has the law changed anything about, the requirements to be, a surrogate or an intended parent? Is that the kind of the same as before? Any major issues that we would want to discuss on that?
I don't think so. The difference now is that it's in a statute. It's just very particular. So to be a
Yeah.
surrogate, you have to be over 21, a resident of the state of Michigan, have had one healthy pregnancy and delivery, and then obviously pass the mental health consultation and the medical evaluation. I mean, it's not really like earth shattering. There's not a lot. And
Okay.
then for the intended parents, it's pretty much you have to have that infertility diagnosis and have been a resident of the state of Michigan. I'm going to add one thing because right now the state of Louisiana, I'm pretty sure only allows it if the intended parents are a heterosexual married couple. I've not seen that in anything in Michigan right now. I don't see that being a limitation or a requirement in the law, so that's great news. So I think we're really lucky with what we're getting in this act.
So
Okay.
Jennifer, if it were, sorry to
No,
take
you're
over,
good.
if it
Uh-huh.
were a same-sex male couple,
Yeah.
I imagine they don't need to have an infertility diagnosis, right?
Well, by default, they have one.
Okay, okay. They don't need to go ahead and
I
have
mean,
a doctor
right,
say they
yeah,
can't get pregnant. Okay.
yeah, yeah.
Okay. So, and this is going to actually, I think, be a pretty good segue into some of the estate planning issues that we'll get
Mhm.
into in a second. But how does, once you have the surrogacy agreement, you have the child, how is parentage determined, right? What is the process for that? Is there a change in the process? Does everyone deal with that in the surrogacy agreement? Do you have to go to court for it? I mean, kind of what happens, post birth, let's call it.
So at about the fourth or fifth month of the pregnancy, you motion the court. Now so this is a process coming up for a parentage judgment. And
Okay.
like I said, as long as your practitioner is following the law and you've checked out all the boxes in the act, really that is almost like an administrative thing. You're going to file a complaint. And the surrogate and her husband and the intended parents are all going to be parties.
Yeah.
But like I said, it's really an administrative thing, and you're just getting an order that says these are your, parents. These are the legal rights of this child. Their names go on the birth certificate. That's really all you're doing there. I think we make it pretty clear in the surrogacy agreement that this is the intent of the parties, and they all
Yeah.
understand what they're doing. So I think it's going to
Well,
be hopefully easier.
Yeah, and it all gets back to that surrogacy agreement. It's the master agreement. It's
Yes.
the foundation in which everything is built on, and it needs to be taken again very seriously because again, if this is more of an administrative process to adjudicate, parentage,
Mhm.
the last thing you want is a large fight in what's otherwise an administrative process, right? People may not have, necessarily the same rights and the same ability to deal with those things if they've restricted their rights in the surrogacy agreement, or if things are left to chance or weren't addressed in the surrogacy agreement. So sounds like again everything gets back to the four corners of that surrogacy agreement. So
Yes,
okay.
absolutely. Did you want to touch on, if you want to touch on the estate planning really quick, that
Yeah.
also goes in the agreement. That
Okay.
is something where there's two things. You have to name a guardian for the child, right? Once the child's born, and you have to name somebody, God forbid, in the event the intended parents die during the course of that agreement, so before birth, who is going to stand in their shoes in that agreement? So when you do an update to estate planning documents, both of those things have to be accounted for in the surrogacy agreement and the update to the estate planning documents.
And I think that's a perfect place to transition, Gabe. If you may be able to talk a little bit about the estate planning side of it, because what we have is a scenario where you have probably outside of the four corners of, hate to say, the norm of estate planning, right? Law always takes time to catch up, right? As demonstrated by this act here, right? So there may be some conflicts, there may be some old estate planning law that may not necessarily have automatically been caught up and may need to be addressed in those estate planning documents. So can you talk a little bit
Absolutely.
about that?
Sure. And I didn't know that that was a provision in the new law until Jennifer just said that, but it makes perfect sense because if you're a surrogate, intended parents die during the pregnancy, you might not intend to raise that child as your own. You have been thinking this whole time, I'm going to carry this child, and then the child is going to the intended parents. Wow, interesting situation. Typically, when I talk about estate planning, I'm typically thinking about what happens after the child is born because I have so many clients who come to me. They know they need wills. They know they have minor children, and if parents are incapacitated or they've died, they want to name who's going to be in charge of raising these children, and they should, of course, have the authority and the ability to make those decisions instead of leaving it to the discretion of the court. So anytime a child is born or something substantially changes in someone's life, they need to go talk to their estate planning attorney. And when I say talk to their estate planning attorney, what I mean is please talk to someone who knows how to do estate planning and doesn't just dabble in it because it can have really serious consequences if it's done incorrectly. For everyone who has minor children, you got to have a will. You need to have a will. That is the only way for the parents to say who will serve as guardian for their minor children if the parents cannot serve as guardian. Without a will, anybody who's interested in being the guardian of that child can petition the court. I always say in my family, I know everybody's got the best interests of the kids at heart, but my mom thinks she would be a great guardian. My mother-in-law thinks she would be a great guardian. The people who we actually want raising our kids are my brother and my sister-in-law. No shade to either grandma, but I want my kids to be with their cousins and with my brother if my husband and I are dead. So everybody, you got to have a will. And then a good estate planning attorney is going to talk to you about the potential shortcomings that a will can have. And by that, I mean a will does not necessarily let your estate avoid passing through the probate court system when you pass away. And in these situations where you've used a surrogate, frankly, you've paid a lot of money for this situation. You've paid I don't know how many thousands of dollars to have this baby. Now let's think about what's going to happen in the future and how do we protect this baby, name guardians for this baby, and also make sure that assets that you leave behind when you die are going to the child or to whoever else you want them to go to, and they're going when you want them to go there. So the kid isn't turning 18 and getting everything all at once, or the court's taking control of the probatable assets because somebody didn't have a complete estate plan prepared. So always these things work hand in hand. And it's important to work with an attorney who really knows what they're doing and what they're talking about.
Yeah.
I have one more, just one comment can I make about something just to think about that's off subject. One of the things that I anticipate is going to happen is health insurance companies are going to catch on. Because right now, if the surrogate's pregnant, that's a medical condition. Her health insurance kicks in, and the intended parents are only on the hook for any extra copays or, whatever is extra following that. So my biggest piece of advice is if you're representing intended parents is to get a copy of the surrogate's or health insurance policy right off and up front. So we know what we are going to be on the hook for. Right now, it's all covered. I haven't seen one yet that excludes a surrogate pregnancy. I will bet that's going to change,
Yeah.
unfortunately.
Yeah. Well, and again, as insurance companies continue, to tighten coverage, tighten the noose there, they're always looking for those sorts of issues out there. The other interesting component of that is from a corporate side. I'm a corporate attorney. I don't do any of this stuff. I know nothing about this. I'm glad that you two are here to tell me about this. Gabe, to your point, don't come to me for an estate plan because I have no. I'll wind up leaving it all to Jimmy Carter. I have no idea how that's going to work, but that's the effect of what I can do on a estate plan. That's why I avoid it like the plague, right? But on the corporate side, insurance and health insurance that you buy for your company is to some degree based on the claims, right? And the amounts and the things that have to be paid out. So in addition to the insurance companies looking at that, I suspect that employers are also going to look at, not that they can do anything to prevent it, right? But again, it's going to be something that's on their radar, I'm sure, in the age of cost cutting here. So, with what time we have left, I know we talked about a lot of things. I want to just kind of recap what I heard here. Sounds like the biggest change that we have out there is we now allow for the paid surrogacy. The surrogacy agreement seems to be the linchpin. It's the cornerstone. It is whatever phrase you want to use, but it is the essential item, sine qua non of being able to get this done here. And it addresses a lot of things, some of which are in the law, some of which aren't in the law, right? So sounds like something that definitely needs to be reviewed by an experienced attorney and parties that really have their eye open as to how this process is going. And it also sounds like there's some estate planning implications that are going to come afterwards that as with everyone, you should have an estate plan, right? The last thing that you want to do is leave it up to a judge that knows nothing about you and a bickering family over who gets what and how things move. So it sounds like those are the biggest takeaways from the session today. Does that sound about right? Am I missing anything?
I think you got it.
Okay, perfect. Well, this is going to be a continuing, area to develop. Jennifer, as you said, it's kind of a brand new law, and the law takes time to catch up. It's the practical effect there. So I'm sure Foster Swift is going to continue putting out resources on its website on this, and I'm sure you'll keep people, kind of in the loop as the law and the related areas change. I do want to invite everyone and let you know about our next session. It's on April 9th. We will be having information coming out shortly on the topic, so please watch your emails for that. And I want to thank everyone for attending today's Wednesday coffee break session on this really interesting topic of paid surrogacy. And again, Gabe and Jennifer, thank you so much for taking time out of your day to talk about this topic. Everyone, the contact information is in the chat if there are any questions. And you can certainly find contact information on the website, www.fosterswift.com. Again, thank you everyone for attending. Jennifer, Gabe, thank you for taking time out. And I want everyone to have a fantastic day and rest of the week. Take care.